All right, everyone. You don't have to be shy. You can come to the front row. It's a big distance. All right, we're going to be getting started. So hello to everyone on Zoom. My name is Andy, and I'm the user experience librarian here at the Riverside County Law Library. Um, and we're very happy to be hosting today's event. This year, our library was selected as a recipient for the Youth and Family First Partner Book to Action Grant. So sorry, I forgot about the mic. Over the past few weeks, the Riverside County Law Library has been conducting programming associated with Native American perspectives, and this grant takes the idea of a book club, but instead of just talking about ideas, the aim is to encourage libraries to take those ideas and engage the community with them. So for our teen programming, we've chose Notable Native People by Adrienne Keene. And then for our adult programming, we chose By the Fire We Carry by Rebecca Nagle. And we held book discussions on both of these titles. And now we're heading into the community engagement phase of the book to action programming with 2 speaking engagements and a storytelling contest. Before I tell you about those and get started today, we would also like to acknowledge that the city of Riverside does stand on traditional ancestral lands of the Cahuilla Nation. And yes, so our first public speaking we're doing obviously is our panel discussion. Next week, we will be announcing the winner of our teen storytelling contest and awarding them with a $500 scholarship. Submissions are still open, so if you know a teen who would like to participate, please let them know. And we'll wrap up on August 14th at the Palm Springs Law Library with a speaker from the Agua Caliente Band of Cahuilla Indians. So without further ado, I'd like to introduce today's panelists. So we have, sorry, they're in out of order from my sheet. So I'll just go off my sheet so that it's a surprise, okay? So first we have Mark Vezzola, Deputy General Counsel of the Pechanga Band of Indians. We have Professor Gerald Clarke, citizen of the Cahuilla Band of Indians and Professor of Ethnic Studies at UCR. We have the Honorable Sunshine Sykes, the U.S. District Court Judge of the Central District of California. And we have Mark Radoff, Senior Staff Attorney for the California Indian Legal Services. Finally, I'd like to introduce you to your moderator this evening, Yanis Azul. And with that, we will get started. For our friends on Zoom, you may notice that your mics are currently muted. Once we are open up to the Q&A portion, we will be happy to take your questions via chat or via voice. And that goes for everyone in the audience today, too. Thank you. Okay.
Sorry, slight correction. We won't be taking voice questions from Zoom. So please type your questions into the chat as they come. Anyways, yeah, my name is Giannis. I'm a library assistant at the Law Library. I wanted to thank everyone for coming out to the Law Library for this event. And I'd also like to thank the panelists for their time and their wisdom on the topics that they'll be questioned about this evening. Tribal sovereignty is a concept I've heard a lot about, but it's not really something I ever delved into too deeply in like my high school education. So when the library decided to pick up Rebecca Nagle's book, By the Fire We Carry, I was pleased to finally learn something about such a shameful and difficult aspect of American history. But I'll be honest, I came out of the experience of reading and discussing the book with more questions than answers. So I hope I can join the audience in seeking some clarity about the nature and future of tribal sovereignty. I'd like to now invite each speaker to introduce themselves and say something on a more personal level about your connection to the issue of tribal sovereignty. So we'll start here.
Good afternoon, everyone. My name is Gerald Clarke. I'm an enrolled citizen of the Cahuilla Band of Indians. Can you hear me okay? Is that? Yeah, so I'm an enrolled citizen of the Cahuilla Band of Indians, and I'm a professor of ethnic studies there at UC Riverside. I also was elected to 2 different terms on the Cahuilla Tribal Council. So I'm not a lawyer, but through necessity, I've had to deal with issues of sovereignty in my role as a tribal leader.
Thank you. Hi, everybody. My name is Mark Vezzola. I am the Deputy General Counsel for the Pechanga Band of Indians located in Temecula, California. My journey to this moment came by way of Massachusetts. I'm from New England. But I went to law school at UCLA to study federal Indian law and tribal law. And I've been very fortunate to be able to work in that field for the last 20 years. First as a court clerk for the Hopi Nation in Arizona, and in my current role. In between, I was an attorney at California Indian Legal Services. I had the honor of serving as a tribal court judge for the Pala Band of Mission Indians and the Chemehuevi Indian tribe. And in each one of those roles, tribal sovereignty was kind of my guiding star. I was interpreting. In some cases, I was drafting or amending. And in other cases, I was defending tribal laws that were adopted by the people of that tribe through an amendment or a voting process. And that's what I had to stay true to as an attorney and as a judge. So it's an honor to be with you today.
Thank you all for coming today. My name is, and for inviting me to speak on this panel. For those of you who organized this panel here today, my name is Sunshine Sykes. I'm a district court judge here in the Central District of California, which encompasses 7 counties, one of which is Riverside County. I sit just down the street at the federal courthouse. I am a member of the Navajo Nation from Tuba City, Arizona, which is up near the Grand Canyon. That's where my family's from. And I kind of grew up all over, but I grew up in New Mexico, Arizona, made my way back to California. I wouldn't say back to, but made my way to California for college. And I also worked at California Indian Legal Services when I graduated law school, and worked on a 2-year fellowship that focused on domestic violence in urban and rural Native American communities. And throughout my work at California Indian Legal Services, I also did some work on working with tribes, representing tribes on issues concerning juvenile dependency and the Indian Child Welfare Act. And that's really was my first, well, other than law school and taking federal Indian law, working with California Indian Legal Services was my first time I really worked with tribes on issues of sovereignty, on issues affecting tribal nations and tribal children and tribal families. And I worked there for a few years and loved it so much, decided to work in juvenile dependency. So most of my career was in juvenile dependency, and representing tribes, then representing parents, then representing the Department of Social Services, and made my way to the state court bench here in Riverside. I worked for 10 years as a state court judge doing a civil trial calendar. And then just in 2022, I was appointed by President Biden to the federal court. So now I handle federal cases. I've had a few federal Indian law cases come before me, but those are really few and far between, because spread out between all the judges that do all types of cases, I would say we get about a couple of those perhaps a year per judge in my district. Some judges may not get any at all. So that's really my path here to be with you all today. So it's really nice to be here. So thank you all for coming.
No one likes to go after sunshine. If you had California Indian Legal Services and dependency on your bingo card, then you can get 3 in a row. But so my connection to sovereignty is peripheral. I started out by trying to get away from California. My name's Mark Radoff, and I ended up going to New Mexico, working for a legal aid program on the Navajo reservation, and then migrated back to California. I worked in different types of legal services, but ended up back working for tribes, working for individuals, also doing dependency, representing parents and children. I was a tribal court judge and am a tribal court judge, and have pretty much worked all the different aspects that would be connected to sovereignty. But sovereignty is it's a tricky term because you're talking about either the tribes is one thing, but individual rights in relation to the tribe. So all the ways that the cases come to us as attorneys or advocates has a piece of that. It's not always presented in that way, but really just trying to advocate for the rights of individuals and tribe self-determination, drafting of their own laws and enforcing them. It's all part of that process. And then, if it goes to the federal courts, that's out of our hands. But so that's my connection.
Great, thank you all so much. Well, I appreciate you, Mark, opening up some of the kind of difficult questions, like in defining tribal sovereignty. So let's go right there. So my first question is going to be, what is tribal sovereignty in your experience, and how do you advocate for it currently? Please take it away, Gerald.
Yeah, thank you. So again, I was elected tribal leader, and I'm not a lawyer, and so I had kind of a practical kind of interaction with these ideas of sovereignty, and it's been my experience that the meaning of it depends on who you ask. Oftentimes, non-native people will see tribal sovereignty as some type of privilege. And I think back, a special privilege for Native people, right? And I think back to there was a group of non-natives in my area on Facebook, and someone posed the question, when did the federal government give the land to the Cahuillas for their reservation? And of course, being tribal and being an academic, I went off the deep end. And it's the same with like the UC system providing scholarships for federally enrolled tribal people here in California. As land grant universities, the university is not giving a scholarship to tribal people. It was paid for 1,000 times over. And so the sovereignty that I think of is something that was reserved for our people by our ancestors is something we've always had. And so in teaching my classes, a lot of smart people at the university, and they all had the same subpar education on what a tribe even is and what Native people are. And their understanding of sovereignty is also, rudimentary at best. And when I was on tribal council, we were basically going to Sacramento and teaching the state legislature about, what tribal sovereignty is. For me personally, as a tribal person, it falls under a responsibility to preserve and protect. I helped write our tribal council bylaws when I was on council, and it was to preserve and protect the land, the people, and the interests of the Cahuilla people. And so sovereignty was like this thing that you were constantly focused on. And you also, and we'll get into it later, but this is something that is under constant threat, it seems. And I think that subpar education that we give people here in California about the First Peoples is one of the major elements of I don't think people are inherently evil, but they don't understand what tribal sovereignty is. And so, and I could give you a good example of this. So I'm on my tribe's housing committee, and we get grants from Housing and Urban Development, HUD, right? And free money to build homes for our tribal members, right? Again, been paid for. But along with that money comes these stipulations. The house has to be this big, have this many bedrooms, it has to be configured a certain way. And in doing so, what the agenda that's being pushed upon us is this interest in having our community mimic a typical American nuclear family in its arrangement. Well, that's not traditionally Cahuilla at all, right? So there's all kinds of little ways that I think my other panelists here can speak about it better than I, but when the 99 compacts went in for gaming, it required that the tribes have to negotiate with the state. And I heard within my community, why are we negotiating with the state? We should be negotiating with the federal authorities, not the state. So there are, constantly these issues that we have to monitor. And we have to educate our own members. Our own members aren't getting the education of our history. And so they might too see it as a privilege, but as I see it, it's a responsibility that when, our ancestors sacrificed so much to preserve, right, and reserve these lands for us and our identities and our culture. And so it's that responsibility for current tribal citizens. I've already done something today in this session. I introduced myself as a tribal citizen of the Cahuilla Band of Indians. And I noticed, I grabbed this book, Rebecca Nagle on the back says, award-winning journalist and citizen of the Cherokee Nation. And so that's something I've been doing now for several years, that's how I am establishing my own sovereignty within my community as citizen. I'm not just a member. I used to introduce myself as a member, but that's like the hair club for men or something, right? And no, I'm a citizen. And I explain to my students, I'm a citizen of the United States, citizen of the state of California, County Riverside, but I'm also a citizen of my tribe. And so that's kind of how I've interacted and tried to protect my community's sovereignty.
Thank you so much. Go ahead, Mark.
Thank you. I just want to echo everything that Professor Clarke said, except the hair club for men remark. I don't think that was directed at me, but I look around and I guess it wouldn't apply to anybody else on this dais. But tribal sovereignty is inherent in tribes. It's not something that was gifted or given or awarded to Indian tribes. It predates the Declaration of Independence and the United States Constitution. It's the way tribes were always operating, to be self-governing. It is their right and their ability to be self-governing. So in my job as an attorney for the Pechanga Band of Indians, I feel like I have a front row seat to matters involving tribal sovereignty, because every time I review a contract for the Pechanga Casino or the Pechanga tribal government, every time I review an application for a grant through the Fish and Wildlife Service or the Environmental Protection Agency, I'm looking at those documents, whether they originate with Pechanga or with an outside agency. I'm looking at those documents through the lens of trying to protect the tribe's assets, but most importantly, the tribe's will. And what is the tribe's will? Pechanga is what we call a general council tribe. So the governing body of the Pechanga Band of Indians is not one person with the title chief. The governing body of the Pechanga Band of Indians is all of the adult members who are eligible to vote in tribal elections. They are the people who vote on whether or not to approve, amend, or even rescind a tribal law. They are the people who vote to approve whether or not to open a casino, which they did over 30 years ago. They are the people who vote into office our tribal council leaders, who are responsible for the day-to-day management of tribal business. So that is tribal sovereignty in the works. And, like I said, I'm very honored that I get to work for the tribe in this capacity. I also want to share, because this just happened yesterday, and I thought it was, I had this panel in the back of my mind. It was kind of an interesting twist on this question. The Pechanga tribal government includes 30 different departments. We have a law enforcement department. We have a fire department. We have, to my knowledge, the only tribal utility department in Southern California, Pechanga Western Electric. We have a social services department and a legal department, and so it goes. But two of our departments had a little bit of a difference of opinion yesterday regarding a project at one of the tribe's properties. It was the environmental department that had some concerns about a building going up on this piece of property. And they were of the opinion, well, this project shouldn't go forward unless A, B, and C happen. I had to remind them that the people have already spoken. This project got the green light from the general counsel. They actually had a vote on it at one of their meetings, and they approved the project to go forward. So while the environmental department had legitimate concerns about protecting cultural resources and about protecting the integrity of the environment, this project has to go forward because that's what the people approved. So that is tribal sovereignty in action, kind of from my little corner of the world.
And I come from a different perspective because now as a federal judge, I'm of course not an advocate any longer. My role is really not to advance any particular outcome, but ensure that the law is applied fairly, justly, every litigant's heard, and that any legal principles governing tribal sovereignty really receive the careful attention that they deserve. I do agree with our panelists that in respect to sovereignty is not something that tribes are asking to receive. Sovereignty is something that tribes have always possessed and something that tribes continue to exercise every day, as my fellow panelists have spoken about. And when I was an advocate, I did, like I said before, focused on the Indian Child Welfare Act. So what is not the most, what is the most important thing really to a tribe is its members, its children, its community, its families, and its citizens. And the Indian Child Welfare Act, for those of you who may not know what it is a federal law that ensures that when Native American children are removed from their homes, that certain procedures have to take place, and to ensure that children aren't being removed solely based on cultural reasons or based upon reasons that are just inherent in who they are as Native people. And that law was passed in the late 1970s and ensures that tribes have a voice in those proceedings. So tribes are able to exercise their sovereignty and have a seat at the table when Native children are being removed from their homes. And that was really my first experience with tribal sovereignty and ensuring and advocating that Native children, when they were removed, were able to remain in Native homes or with other Native families, and in order to ensure that the culture could continue to thrive and those children would still be connected to their culture when they had to be placed out of their parents' home because of allegations of abuse or neglect. Now, as a federal court judge, as I said, I don't advocate for a particular position, but I am in a position that I recognize and understand what sovereignty is, not only as a citizen of the Navajo Nation, but based upon my past experience and work throughout my career before I became a federal court judge. So now I see it as, my responsibility, as Professor Clarke said, is to make sure that I'm in a position where I can also use my position to educate other judges about issues concerning Native American law, issues concerning sovereignty, because it is still, I think people don't truly still understand within the legal community, within and outside the legal community, that tribes are functioning, tribes have functioning governments, and tribes have functioning courts. And people tend to focus on the difference, going to a tribal court and saying, well, they don't do it this way, and this is how we do it in state court, or going to a tribal court and saying, well, this is different than we do it in federal court. And in that respect, seeing tribes as not those governments and those courts not being legitimate governments or courts. And I think there does need to be education across the board when it relates to tribal governments and tribal courts and tribal sovereignty. And now that I'm in a position in the federal court, I've been able to get on different, committees, one of which is the Ninth Circuit Education Committee. And just a few years ago, we had a judicial conference solely for Article 3 judges, meaning district court judges. And I had a panel that specifically educated federal judges on tribal courts. And this was housed, our event was in San Diego. So I was able to get three individuals to speak on the panel specifically about tribal courts. And then in the afternoon, a bunch of federal judges got on a bus and we took them out to Paula Tribal Court. And then we went to the Intertribal Court of Southern California and we visited with tribal court judges and tribal leaders from those communities, and just kind of having that interaction between tribal judges, federal court judges, tribal council members, and federal court judges really opened up the eyes to all of those judges who got to experience that. And there were Ninth Circuit judges as well, which is the next level of the Court of Appeals, essentially, for the federal courts. And I think that's vitally important because judges who don't have any connection to Native American communities or Native American tribes or tribal people, they may get a case. Like I said, I get, a handful of cases a year or every 2 years, and they may know nothing about what it really means or to live and to exist on a tribal reservation and be governed by a tribal court and a tribal government. So it was really eye-opening to those judges to be able to go out to a reservation and see it with their own eyes and say, okay, this is what a reservation looks like. Because I think those of us who have worked in federal Indian law, it's just like a given, like you just know, or if you grow up that way, you just know, like it's not something you have to be taught, you just know it. And so I think now being within the federal court, it really opens up experiences where I'm able to share, my perspective or my community and where I come from, and share that with other federal judges so that they then can understand and see a different perspective of Native nations and how Native nations are truly exercising sovereignty from their reservations up to their tribal courts and through their tribal government. So there's different ways in which I take that responsibility now that I've transitioned from an advocate to a judge.
Thank you.
So everybody took all the good answers. I would agree on almost on everything. Sovereignty is a pretty misunderstood concept. I think that from the outside, people probably tend to think, oh, it's like you want some special treatment, like diplomatic immunity or something, and it's the wrong flip. So the sovereignty was there when this country started, and the sovereignty, it'd be like if you went to the Colorado River and said, oh, I'm going to grant you the ability to flow. Well, it was already flowing. Or I'm going to let you be this state boundary. Like that land was already there before. Nobody created it. But that's kind of the way it looks from the outside. And it really is, there's so many different aspects, things that we probably won't think of right now, but not just having meetings, and I think people tend to think, oh, okay, how do you have these meetings to decide? You have to first find a cave and a talking stick, and you have to sit in a circle, and none of that happens. Or it might happen, but not the general council meetings I've been to. But there's, the hunting rights, the fishing rights, things that were already happening before. In the Northwest, some of the, there were cases over whether shellfish under the ground are fish, if they count. Just all the things that really were part of the life of the tribes and the members before are still there. They're still retained. And another aspect is the government to government relationship. You can get a tribal person really mad if you say that they're equal to the counties or analogize them to the counties. the government to government relationship is a different type of relationship. And that's why a lot of times you might, it might seem like there's an attitude or something, but it's really an insult to downgrade, to try and convert a tribe into the Parks and Rec department or something. And that's sometimes how it feels, that you have to follow our laws, that, well, this is not how we do it. This is, just the, which laws apply. So when you get to looking for immunity in contracts, one of the big issues is sovereign immunity, which is part of immunity, and that stems from the idea that the king can't be sued, that you cannot sue the nation, and that applies to tribes as well as the federal government. And that it's a battle on every single step of the way. It's a battle, which laws apply, how far it goes, who it applies to. Does it apply to the government, elected representatives, to the employees? Each little thing. And that's what we look for, at least what I look for in when I'm looking through a contract. Things that just seem like, oh, that's just the way it is. They really aren't. And the self-determination, at least in my experience, there's more of an immediacy with a general counsel tribe. So it's a smaller group. There's in the best case scenario, there's a more congeniality, although that sometimes doesn't happen. But everyone can speak, and you'll listen until that person's done. And there's a cause and effect between things that happen right away. You don't wait. You don't have to go to a committee. You don't have to go through lobbyists. You don't have to go through a series of amendments and then another body. Like it could just happen right then and there. When I was in-house, I wrote the law. I wrote an ordinance and then presented it to the tribal council, who presented it to the general counsel, and it was done. And we had to do that, some of that in real time during COVID, for things that we had not expected. How to enact an emergency ordinance, how to ratify acts for the council that couldn't be passed because they didn't have a quorum, because we were supposed to quarantine. So there, but all those things that happen, the inside baseball of tribal politics, there's a more of an immediacy, and I think that is missing in the politics that we have now, at least in a bigger sense. And there's probably less red tape too. So there's not really, well, you got to talk to that person, they'll go talk to the chairman, and the next thing you know, they'll be at your office. And so it's, what was the question? So I think that my experience with sovereignty is it really just it comes up every single time, but you don't always think of it in that way. So that's what I have to say.
All right, thank you all. So I appreciate everyone placing an emphasis on the way that sovereignty is not something that was granted. So I wanted to get a little bit more into that long history of sovereignty. My second question is going to be, what continuities do you see with the ways indigenous nations governed themselves and defended their sovereignty before colonization with today? And please take it away, Gerald.
Yeah, thank you. So in my classes, and I'm glad that was brought up. So when I talk about sovereignty, I'm talking about inherent tribal sovereignty. So, European nations were signing treaties with tribes before the United States even existed, right? And so there's a precedent there. And, so with my band of the Cahuilla, we had a big change in how we govern ourselves around 1912. There was a meeting and a melee happened, and the superintendent of the Bureau of Indian Affairs was shot and killed right there at Cahuilla. And up until that time, we still followed our traditional governance system. So traditionally, you had the community leader called the net, and then that person had an assistant called the pahal, and they made the major decisions in terms of ceremonial calendar. They worked with the puvalem, who were the shaman, and that's how it was not a democracy. I think we've all been kind of brainwashed in our educations to think that's the only way of governing that's valuable. But there was a communal identity, And the person who was the net was this consensus, you know, and if you had through hereditary line, if you had someone become the net who was incapable, the people just would quit following that person, right? And then they would follow someone else and you'd start a new line. So that was our traditional form of governance, again, predating the United States. But what happened after that melee and the bureau superintendent being killed was, first of all, they tried 11, I think 10 or 11 men for the murder, even though it only takes one to pull a trigger, right? And sent them to prison, including my great grandpa Pio. And then they forced Cahuilla to have a tribal council. You know, it was based on some kind of civic organization where you have a chairman, vice chair, treasurer, secretary, and such. And so we've been governing ourselves through that system ever since then. Before this happened with our traditional form of government, there are letters in various archives over and over again. Our traditional leadership were saying, give us a deed to the reservation and then leave us the hell alone. There was nothing that was wanted from the federal government, but they wanted a deed to the land because they kept having non-native people trespassing onto the lands. And that was the only way they knew that they could fight back in terms of these trespassers. After we switched governance to more of a democratic general council kind of approach where everyone would vote on different issues, I think the ideology of the tribe changed a little bit. And it became more along the lines of, okay, the federal government has done this to us, so now they owe us, right? And even today, you know, I teach at UC Riverside and I have health insurance and those kinds of things. I still go to Indian Health. It's our very own third world system here in California. But I go because I felt like it was owed to me. You know, we got to continue to use that because of the sacrifices, right? The ancestors made. And so in 1970, my dad was chairman of my tribe, and he brought the first housing program from the federal government to build houses for tribal members. And he proposed that to the tribe, and his own mom voted against him. And it was because that she was that old school kind of way of, you know, nothing's for free, right? And this distrust of the federal government. Eventually, we started doing that, but that traditional form, and Mark here has worked with my tribe, so he knows we're a little bullheaded and very strong in our opinions. And I think that, you know, that's held true throughout whatever system we have. That's held true throughout. And actually, I've heard people in my community starting to say that maybe it's time to return to a more maybe a hybrid version where different clans or families have a representative, and that's how we form a tribal council, as opposed to just electing, you know, in some kind of general election. But that's been the evolution of our form of governance. Yeah, I imagine, you know, we've been here a long time immemorial, right? So I could foresee that it's going to continue to evolve and change with the times.
Thank you. So in my role at Pechanga, one of the things I do is I work with the tribal court. So not all Indian tribes have their own courts or judicial systems. Pechanga does, and it's actually a three-part system. We have a trial court, we have an appellate court, but we also have what we call a peacemaker forum. And the most famous example I know of comes actually from the Navajo Nation, Judge Sykes's tribe. But the idea of the Pechanga Peacemaker Forum is restorative justice, to provide tribal members a forum where they can bring disputes and disagreements to be resolved in a way that leaves everybody feeling whole again, rather than presenting them to a Western style court, which is inherently adversarial. And typically we think of it in terms of winners and losers. And as a matter of fact, the Pechanga Peacemaker Forum predates the Pechanga Tribal Court by several years. And I believe that the Peacemaker Forum is kind of following a direct line back to the tribe's history, the way they resolved disputes prior to European colonization and the founding of the United States, where people who, because they were elders, because they were wise, because they were experienced, would help other people in the community work past disputes because they were all part of a community. They were part of a tribe. They were part of a culture. They were part of a family or a group of families. So when the Pechanga Peacemaker Forum came into being formally, I mean, in the 21st century, I wasn't working there yet, but from what I've heard and from what I've read through the documents, it started to look and act more like a Western style court, which was getting away from the intention set out in the Pechanga Peacemaker Ordinance, which was adopted and approved by the General Council, the adult voting members of the tribe. So the tribe decided, well, this is going to work for some things, and this is a service we're going to offer our people, but this is also 2013, it was at the time, and we also need a way to resolve disputes where we can walk away with an order that can be recognized by other courts, state courts, federal courts if necessary. So the Pechanga Band decided to adopt a judicial ordinance and develop its own court system. So why might people use the court versus the Peacemaker Forum? The Pechanga Court's a court of limited jurisdiction. So its jurisdiction is dictated by the terms of that judicial ordinance, the document. These are the things that are within the tribal court's jurisdiction. One of those things is what we call juvenile dependency or child welfare cases, which I think everybody on the panel has talked about today. So when a child is reported to be the victim of abuse or neglect, our social services is authorized under a different tribal law to do an investigation, and if necessary, if they believe there is a threat of harm to that child, to remove the child from its home. So those cases are brought in the tribal court rather than in the Peacemaker Forum. The tribal court is also empowered to hear disputes involving tribal business leases, to issue protective orders for victims of domestic violence and their families. Whereas the Peacemaker Forum, it's a group of tribal members who are specially trained to facilitate these groups, but they are not there to dictate orders or tell people what to do. They're there to help people find a way through it. And, the success is really if there can be some kind of agreement or consensus between the parties at the end of the day. And I think it's a great idea. It's slowly becoming more popular within the community. It has a lot of support from tribal council. And I think more people are learning about it and thinking about that before they think about going into tribal court. But at Pechanga, they have both options as long as, number one, their issue is something within the tribal court's jurisdiction, and number two, if they want to go to the Peacemaker Forum, one condition is that both parties have to agree to do that. In other words, you can't force somebody to go into peacemaking as a form of restorative justice. You all have to be open to it. But that's one of the very few requirements.
And just, for perspective, because we don't know who you all are, we didn't introduce you all didn't introduce yourselves, but every tribe has a different system, right? It doesn't all look the same. So Professor Clarke talked a little bit about his tribe and how his tribe functions. The Navajo Nation, which is my tribe, functions a little differently. Pechanga functions a little differently. All the tribes here in Southern California and across the country have different forms of tribal governance. And they also may have different tribal court systems that function a little bit differently than each other. So just keep that in mind when we talk about sovereignty and tribal governments and tribal courts. Tribes, because of their sovereignty, can create their governments in whatever manner that they choose. It could be more focused on a traditional form of governments. It could have evolved over centuries. They could go back to a more traditional form of governments, and the same with tribal court systems. They don't always look like a state court system or function like a state or a federal court system. And there are possibilities, or there are tribes that have peacekeeping courts and have restorative courts. For example, I think it's the Yurok tribe in Northern California has essentially a peacemaking court that does do juvenile dependency, ICWA type cases, and also tribes have youth court as well, which are similar to youth court systems that we have through the state of California, where it is the function of the court is to restore balance and to make whole, as was spoken about. And the way that functions with youth court, which perhaps may be different if to a tribal youth court or a state youth court, is that if you have a youth who's picked up for, let's say, a misdemeanor crime, if they volunteer to go through the youth court program and go through that program successfully, then their record is essentially expunged, or the charges are then dropped. And so they're able to have a clean record in their future. The way that could work in tribal court, youth court, is that, let's say a youth was going around the reservation and maybe did some graffiti, or maybe did something to affect somebody else within the reservation, maybe broke into a home and took something. The tribal youth court and the way that would function would really focus on, what can this youth do to give back to the community and to make the community whole again, which means they may have to go clean the graffiti. They may have to volunteer at like an elders feast. They may have to take elders to go to doctor's appointments, things like that. It's really kind of outside the box of thinking of, the traditional punitive punishment. You do something wrong, you go to jail. And so all of those concepts of really living in harmony and making the community whole are found within, I would say, most, if not all, tribal communities. Even if you don't have, a traditional court or a peacemaking court, those values are still there. From a perspective of history, going back to really what I talked about a little bit before, I think history does matter, and understanding history of tribal communities and tribal nations really does matter when judges are deciding cases, and when judges are able to understand and have that perspective of the history leading up to the issue that's before the judge. That's really vitally important, and it matters in ways in which I can give you an example. When I was an advocate before I became a judge, I worked, as you know, in juvenile dependency cases, and I represented tribes, and then I moved over to representing parents, and I worked here in the county of Riverside for all of my career, really. And when I first was here in the county as an attorney, I noticed a lot of kind of disgruntled other attorneys and social workers when it was a case involving the Indian Child Welfare Act, because it was more work. You would have to retain an expert witness to ensure that the children weren't being removed solely based upon cultural reasons, and that there was actual, and really to talk about a little bit about the tribe's culture and traditions. And there were other steps you would have to do as a social worker to provide services to Native families and Native children. And I saw that, and I didn't quite understand that, because it was a federal law. It was something that needed to be followed, and regardless of the more work, it was important. But I understood the importance of it because of who I am and where I've come from and my background and my family. And I knew the history of why the Indian Child Welfare Act was passed and what was going on before the act was passed. And I started kind of thinking about it. It's like, well, these social workers and these attorneys, all they know is they have to do it, right? They don't really know what happened before. And I started to focus a lot on providing training as an attorney and then as a judge to really go back in time in history of the different governmental programs that really targeted destroying Native families, Native communities, and Native children, and teaching that history, the Indian Adoption Act, the Indian boarding school era, and teaching social workers, teaching attorneys, teaching judges of all the atrocities that affected Native families, Native communities that led up to why the government decided and Congress decided to pass the Indian Child Welfare Act. And once those social workers, the attorneys, and those judges were starting to understand the history, then they were more invested. They were like, okay, this is a Native child, and this is what's happened historically to Native families. And now I get it. And I understand why it's important. I understand why I have to take these extra steps. I understand why an expert is needed, because that was lacking. So I think it's vitally important as advocates, as attorneys, as social workers, as judges, not only in relation to the Indian Child Welfare Act, but in relation to all of Native history and Native communities' interaction with the federal government, to really understand that history when a case is coming before a judge. So beyond kind of what's in the briefing or what the attorneys have given, but understanding just as a whole what tribes have faced in respect to sovereignty and governing themselves and their own communities.
So the question is continuities that I see in history from before colonization. And I don't think, I'm not qualified to answer this. I'm not a historian, so I can tell you what I know now. And I think maybe just to steal Professor Clarke's comment, I'm a member of history, and maybe it would be better to be a citizen of history, because the cause and effect that happens now is a result of some ownership in how the prior events caused us to have the system that we have now. And I think the colonization is probably a misnomer or trick to the question, because I don't think there are many, if any, tribes that think that they are part of the U.S. in that way, that they have been absorbed into the system. They have their own systems that have endured, and in the process of doing that, they've gained some momentum in trying to create an analog, but it's not the same system. It's not a mini-me. It's not a replication. But in 1934, the Roosevelt administration, among a million things that it passed, was the IRA, Indian Reorganization Act, which basically tried to turn tribes into little democracies, little Americas. And not every tribe followed it. Not every tribe to this day even opted in. But the template was, you have to have a written document, a constitution, and articles, something, a leader. You have to have these things because we don't recognize you otherwise. And part of that was so that in the cynical scenario where certain companies or governments could get resources because they had a person who was on paper authorized to sign, so they helped them create their government, which was already there. And the things that have endured are custom and tradition. There's parts of the history that are oral, that were not passed down on a parchment, on a pen, in a book, on a train, in a plane, none of that. So they and if you think about it, there's places where we operate the same way. At home, we don't write things. Some people do, but some of my kids do. But you don't write everything down and say, okay, this is what we're going to do. These are the rules. You operate within a structure that everybody knows, and then it is passed down. And that is, that may not be something that non-natives understand, but it's not like we said before, it's not granted, it's not created. It's the rules that were already there that are now being understood a little bit better. And I wanted to mention on the Indian Child Welfare Act, there was a time before the ICWA where, and it was the early 1900s, late 1800s, or early 1900s in the East Coast, where the United States and in conjunction with some church groups just took kids off the streets, put them on trains, sent them to good religious Christian homes. And they were called the orphan trains, and it went on for like 50 years. And these are kids that are just walking along, doing whatever, got snatched, taken to a new home. They took them out of the train. They paraded them out. They got picked like in softball. The ones that didn't get picked got back on the train and kept going. And that structure of just taking children away from their culture to try and to convert them into a better culture started before they figured it out with Native Americans. But the Indian Child Welfare Act was the moment in our time when they put the foot down and said, we're not going to do that. These are some separate rules and some guardrails. So a lot of the advocates in that field just don't like the extra rules. They feel like it's special treatment. So as far as what carried on, I really couldn't tell you. I can tell you that it's different and it should be different. And if you want to take the time, there's 577 different versions in the U.S. And that's not even counting the non-federally recognized tribes. Those are the tribes that the federal government says we acknowledge you as a tribe. There's yet another large group of unrecognized tribes that don't get those same benefits, and that's created a sort of a have and have not dynamic, which when you balance the equities, why should one government get to decide if this people exist or not? But that's beyond the scope of this question.
Well, if you wanted to add a little more on that, you can.
I don't, because I've when I've worked with, I must have time on the clock. If they're the tribes who are recognized within that group, there's the ones like I used to tell people, I still tell people, if you've never heard of the tribe before, that's my client. If you've heard them, they're not. So the ones that have a big name and a big building and they're by the interstate, then those aren't my clients. But there's others that are in even darker shadows, and that the have and the have-nots, that's not anything that we can really fix, but we can not exacerbate it. And so I think from the tribal government perspective, you want to give a voice to all the governments, because there's multiple layers of relationship. Like when Batman played three-dimensional chess, there's tribe to tribe, tribe to state, tribe to federal, tribal members to other tribal members, tribes to consortia, tribes to trade groups, tribes to educators, academics. There's all the different roles, and they all are part of the same identity. But so I think the idea of letting someone or some government be a kingmaker, recognizing someone, is probably it runs afoul of how most tribes consider their identity.
All right, thank you so much. Actually, we are running up against time. So if I could ask just really quickly for our last question.
Time is a Western construct.
True. I'll throw up a 2 when we've hit like about 2 minutes, and it'll indicate to wrap up. But what are the most important goals for advancing tribal sovereignty over the next generation, and what obstacles must be overcome to achieve them? I understand it's that's an extreme question, but please.
So is this the lightning round?
Yeah, this is gonna be the lightning round.
I'm real pleased hearing from the other panelists. What I hear is education, right? And so I think it's not enough to understand the textbook definition of sovereignty. I think within my tribe, what we have to do is raise up our youth and educate them into what it really means, this kind of responsibility. And then that gives them the foundation to move forward and to do the battles that are they're no doubt going to confront as they become tribal leaders themselves.
I think one of the important goals is to not take tribal sovereignty for granted, because there have been concerted efforts over the years, really over the centuries, to diminish and to absolutely take it away from tribes. So I think we all agreed that tribal sovereignty is something inherent in tribes, their right and their ability to be self-governing. But it wasn't that long ago. Mark was talking about history a moment ago. It wasn't that long ago the United States government was actively terminating Indian tribes. Now, how do you terminate an Indian tribe? Do you do it with a ray gun? Do you do it with, like, you know, a blink of an eye? Well, what the United States government started to do in the 1950s after World War II and after the start of the Cold War, because they didn't want the quote unquote responsibility or financial obligation that came along with their relationship to the United States government that the United States itself formed in the preceding 150 years, they came up with this system of terminating Indian tribes by ceasing to recognize them as political sovereigns, taking away any kind of grant money or financial opportunity that came with the United States government's trust obligation to Native nations. And as a result, 100 tribes lost, and Mark mentioned this term earlier, their federal recognition. And with the loss of their federal recognition, many of them, not automatically and not necessarily right away, but many of those tribes lost their land bases, their sources of income, and found themselves under state jurisdiction, perhaps for the first time in recent memory. So there are people today who continue to challenge the validity of the Indian Child Welfare Act, Congress's right to pass laws like the Indian Child Welfare Act. So I think tribes need to be vigilant to maintain their tribal sovereignty into the future.
Thank you. Please go ahead, Judge.
Just the same as Professor Clarke said, I think definitely the next generation, it depends on education, and not only educating judges, educating lawyers, educating law students, future lawyers, and the public about what federal Indian law and issues of sovereignty. We do need more Native attorneys, judges, and leaders serving throughout the legal system. I have been fortunate enough to have a few law clerks, and those are recent law graduates who are Native and who have gone, who have taken federal Indian law and are aware of, what sovereignty is, what sovereignty means, and who have been able to work for me and assist me in my cases. There's programs out there that pipelines for Native American students who are interested in becoming lawyers, who help Native students get into law school. The University of Mexico has a pre-law summer institute where entering Native law students can take essentially a full year's worth of their first year of law school in 12 weeks. To better prepare them to be attorneys and advocates. So I do think that there needs to be a focus on really reaching back and helping our youth understand that they can become Native attorneys, they can become judges. On the federal court right now, there are 5 Native federal judges. We're all women, so the men need to step up. But, that's 5 out of, I don't even know how many federal judges there are, 400, 500 judges across the country. And in the history of the United States, there may have been, a few more, but definitely less than 10 Native judges federal judges in the history of the United States. And so I do think that there's a need for education, and then also a need for more Native American youth to make their way to become attorneys and judges.
So I'll be forth to echo on the education, but the outside of tribal communities, there needs to be an understanding. It's not just all about gaming. That seems to be the only thing that gets all the focus. And I've worked a lot with the tribal courts, and one of the reasons I think tribal courts are important, it's a three-legged stool, and you can have the legislature and you can have the council, but without the court to put that into action, that's really the way that you're self-governing. And the perception outside is it's a kangaroo court. It's not a real court. And that needs to be knocked down. On the tribal side, I think the tribes need to one of the threats is Robert Rules of Orderism. I can't tell you that this is my bias, but when I hear a tribe being run by Robert's Rules of Order that came from England before we were the US and tabling something for some reason, I don't know why it applies. I don't know why we use it. I don't know. I don't even know who Roberts is, but that needs to not happen. But the education is really the key, because the tribes have, there's territorial sovereignty and there's tribal governance, but in the same way that you couldn't Riverside City couldn't go over to March Air Force Base and say, hey, we're going to pass an ordinance that says you have to do this. It's not their land. They can't do it. It's federal land. The tribes are the same way. So getting that message out, letting it be understood, it's not punitive. It's not special treatment. It's just different. And we live in a different world where everybody has to operate independently and sometimes together. So I think that message this is a start. We have some people on the screen and also in the room, but just ask more questions. There's not enough questions. But I'm not inviting anybody to ask. I'm saying that metaphorically.
That's a perfect segue.
No.
Well, thank you guys all so much for answering my questions. I've learned a lot, and so hopefully, I'm gonna walk up to the center aisle and invite as members of the audience. Go ahead and raise your hands, and then if you guys have any questions. Yeah, go ahead, Richard. Come on up to the center.
So that I can better understand the notion or the concept of sovereignty between the tribes and the United States government. Are young men, citizen tribal men, are they required to sign up for the draft?
I think so.
Yeah, I think so. Yeah.
Okay. Then I kind of blurs the thing with sovereignty for me.
The federal government blurred it for you. So even though the tribes have sovereignty, I forget the terminology, it's plenary, but they can be taken away. Aspects can be taken away by the federal government. That's not by design on the tribe side, but there are parts of the federal system that apply to the governments, the people, that wasn't their choice.
All right. Anybody else in the audience got any questions? We've got a couple on Zoom.
And just to not to necessarily answer your question or give you a more detailed answer, but this is what's so complicated, right? Because sovereignty, the idea of sovereignty and having a nation within a nation, and then we have three sovereigns, right? Federal government, state government, tribal government. And I think, as we stated in the beginning, that's not taught in school, right? You're not taught about tribal sovereignty, or most kids don't even know that tribal governments exist and that tribes are sovereign and have their own functioning governments and own functioning court systems. We could probably have a whole 3-day or a week-long conference just getting into all of this. So it is really complicated, and there's different jurisdictional issues that come up. And so I think all of us can agree that that's something that we would advocate for, is education and having our schools being taught that, our colleges being taught that. As a first-year law student, you're not required as a core course to take federal Indian law. It's something you can choose. It's an elective. And that's something I think that every lawyer should know, at least be required to take a federal Indian law class. Mhm.
So you two want to take a stab at that, but otherwise, anyone in the audience? All right, no worries. Okay, I'm gonna venture under the speaker. Let's see if that. Okay, let's see. Okay, so here's one question from the Zoom chat. They said, given that many tribal governance structures were shaped by or modeled after colonial democratic frameworks, how can indigenous nations build internal accountability and transparency, ensure tribal councils serve their communities without inheriting the corruption and systemic flaws of federal politics? Um, yeah, go ahead.
It was,
Go ahead, Gerald.
yeah, so I'd mentioned this event that happened that changed our tribal government back in 1912. And so and then the IRA was brought up, where Indian Reorganization Act, where there was this carrot and stick approach by the federal government of trying to get tribes to adopt constitutions. So this system was imposed on us, but we never did adopt a constitution. And we say in our meetings, we govern ourselves by customs and traditions, right? So I think there's still a way. And again, instead of looking at it as new systems being imposed on the tribes, maybe try to look at, I think about, again, my ancestors and the perseverance and the ability to adapt to new situations in order to for our people to continue to exist and to thrive. And so I don't see it as completely switching gears. I just think it's part of our evolution as people. And as I said earlier, I can see us evolving to something else eventually that, something that's going to work for the time that our people find themselves in.
Yeah, I have kind of a similar perspective from my work for Pechanga. Pechanga has a constitution and has had that constitution for almost 50 years. But that constitution laid out a very bare bones framework for the tribal government. Everything else was adopted. I mean, the Constitution was adopted by the General Council, but everything else within the tribal government was originated and shaped by the people for the people. And in terms of, avoiding the corruption that may plague other governments, I mean, I'm not sure that any government can escape those accusations, but in our tribal government anyway, there is an emphasis on transparency. There are mechanisms to remove people from office, but more importantly, there are ways for tribal members to put issues involving the elected tribal leaders before the general membership and to call them to task. So, and I don't know if it's so different between general council tribes and other tribes, but I do feel that the Pechanga tribal government anyway is a government of the people, by the people, for the people. So the elected leaders only have as much power as the general council gives them. And if they gave them that power, they can take away that power. So.
And you two want to take a stab?
The only thing I would say is the transparency at the end of the question is a problem, because transparency cannot be oversight. Transparency for whom? If it's transparency for the tribes, the members have that. So if it's transparency that someone else is going to judge whether they're doing it right, I probably take issue with that part of the question. I think I would agree that the blanket of democracy that was given to tribes, maybe it came with some smallpox, but and those are problems that they're going to work out on their own. It's not going to be because it doesn't align with a larger vision of how tribes should govern.
All right, thank you so much. All right, I guess this will be our last question. Um, oh, sure. All right. So this is another question from Zoom. It is, what is the future of the Congress or BIA recognizing larger jurisdiction for tribal courts in criminal matters arising on tribal reservation lands?
I'd like to answer that.
Please.
So tribes do have, okay, so criminal jurisdiction, really any kind of jurisdiction. It can be a mishmash, it can be a really complicated law school exam question, but it's also reality for many people, people who are citizens of tribes, people who live, work, or visit tribal reservations for whatever the reason. So tribes do have, many do not exercise it, but they have criminal jurisdiction over their members. Whether or not they have criminal jurisdiction over non-Indians is another question, and it's a very fact-specific question. So, here in California, while generally in other parts of the country, only the tribe and then the federal government of the United States have criminal jurisdiction on Indian lands. We are living in what we call a Public Law 280 state. It's a law from the 1950s where Congress basically transferred the federal government's criminal jurisdiction over Indian lands to a handful of states, including California. But this question, I think, is more about the tribe exercising criminal jurisdiction, I think. But that's the state of California having criminal jurisdiction over Indian lands within the boundaries of California. Whether or not a tribe has criminal jurisdiction over a non-Indian within its territory, within its borders, largely depends on whether or not they opt into what's called enhanced criminal jurisdiction under a law called the Violence Against Women Act, which was first passed in 1994 and has been reauthorized over the years. But generally, tribes don't have that criminal jurisdiction over non-Indians. There was a case that went up to, it was out of Washington in 1978, that went up to the United States Supreme Court, where the court came back with a pretty devastating decision for Indian tribes, saying that criminal jurisdiction over non-Indians was inconsistent with the tribe's quasi-sovereign status. That's what it said. So basically that it was devastating because it meant that Indian tribes could be facing criminals within their midst, but may have no recourse or remedy to deal with those crimes. They would have to depend on a law enforcement body or a district attorney from another jurisdiction to kind of hold those people accountable for their actions. But I think gradually over the last couple of decades, as more tribes are developing tribal courts and tribal court jurisdiction is expanding, I think we're getting away from that, and I'm hopeful within maybe your lifetime, tribal courts will have that jurisdiction to keep their communities safe.
Okay, thank you so much. Any responses? No?
No, I was just going to say, and that goes back to why education is important, because a lot of, judges making these decisions don't really understand, the nature of Indian country and how broad and how large Indian country is. And if Native people, let's say on the Navajo reservation, if something happens in the middle of the reservation, and then now the victims of that crime have to wait, for the FBI to come out or someone to come out and arrest someone, by the time that happens, that person's long gone, right? And so just the realities of these jurisdictional issues and how they affect Native American communities, is understanding that is really important, and that understanding and knowledge does filter through all of these cases going in front of federal judges, state court judges, having that knowledge.
There was a case in Bishop in recent memory where in California where a tribal police officer detained a woman who was had a warrant or a restraining order, and there was a DV, domestic violence circumstance. But when they called the sheriff to come pick up the person, they arrested the tribal police officer. And that, I don't know if it went to the Supreme Court, but there's, California's a lot more confusing than other states like New Mexico, Arizona. The lines are a little bit clearer between major crimes and crimes that the tribes have jurisdiction over. But it's a work in progress, and I don't know that the BIA is going to be able to solve that.
Yeah, in this kind of vein of education, I know of a tribal member from the Torres Martinez band of Desert Cahuilla Indians who retired out of the Riverside County Sheriff's Department and then made a whole second career out of training sheriff's deputies on Public Law 280 up and down the state. And, you know, sometimes in my capacity as a tribal council member, I found myself almost stuck in a bad Bruce Willis crime movie where different, you know, agencies are arguing over who has jurisdiction. And at one time, I live on the reservation, and someone, probably a non-member, stole a welder on a trailer and cut through the reservation as a way to avoid the highway patrol. And the wheel came off of it, and it was blocking the road on the reservation. And so a member called me and said, "Hey, what are we going to do?" And I said, "Okay, let me handle it." I called the sheriff's department, who has jurisdiction there on the reservation, and they said, "It's in the road." No, that's highway patrol. And I called highway patrol, and they said, "It's on the reservation." No, that's the sheriff. So I just got my tractor, went down there, and I just put it in the ditch so we could drive by it. And it's so frustrating, right? And so this education, right, of educating, the education doesn't need to happen, you know, on the reservation. It needs to happen throughout the state through agencies, again, state legislature. And it can be very frustrating, I think, to try to be a tribal leader and navigate these kinds of the ignorance over the laws of the land.
All right, so we've got this is more like a comment, but you know, feel free anyone to respond to this. It's from Zoom. Can we please advocate that judges and attorneys are trained on ICWA across the nation in dependency divisions because the costs are high as it relates to our tribal sovereignty? Not particularly sure.
I mean, I think all of us have really spoken to that comment, the importance of educating advocates, educating judges, educating social workers, and why that matters. So I think we all agree with the commenter, saying that it does definitely need to be done. And, you know, it needs to be done throughout the state, throughout the country. Because you may, you know, my reach when I was an advocate may have only reached, you know, Riverside County, San Bernardino County, but then you have Northern California, you have the Central Valley, and all of those, you know, advocates and judges and practitioners and social workers also need to be reached. So, you know, putting larger systems in place, like trainings through the California Bar, or trainings through, you know, the larger federal Indian bar, or there are resources and ways in which that training can be brought to those individuals who are practicing in that area. And there are ways in which, you know, I would go straight to law school, even like I said before, having a required course on federal Indian law in the first year for the first year law students. And that would hopefully touch upon, and it should touch upon, the Indian Child Welfare Act and the history of that as well. So then you have young attorneys who are going into practice that understand that as well, especially if they want to go into juvenile dependency law. And I think at the state of California level, when I first started as a state court judge, when you would go to take a week course, training on juvenile dependency, I think there was one course, maybe 1 hour class or 2 hour class from the entire week that was training judges on the Indian Child Welfare Act. That may have changed because that was back like 2013, but certainly there are ways in which those systems can change to provide that education.
I definitely want to second that comment. I think that kind of education is extremely important. I just heard recently that the Uniform Law Commission, which is kind of a body that recommends or advocates for best practices and adopting new laws among the various states in the country, recently took a step towards adopting a model Indian Child Welfare Act that's designed for states. So the Indian Child Welfare Act we've been talking about on the panel is a federal law that Congress passed in 1978. But what the Uniform Law Commission has come up with the help of tribal attorneys, attorneys from the California Tribal Families Coalition, Kimberly Clough, tribal court judges, what they have come up with is a model that states can adopt on their own. And this was always the idea. The Indian Child Welfare Act, the federal law, was meant to be like a baseline, a minimum that would have to be applied and followed in all 50 states. But it left open the opportunity for states to adopt their own laws with even higher or stricter standards. Now, as Judge Sykes said, some people might roll their eyes and think, oh, that just sounds like more work. But at the end of the day, it's about protecting tribal families. Okay, there is a reason. There are people, there are families behind that extra work. I think that's a really good step because different states have different populations. They have different relationships with their tribes if there are recognized tribes in their state. But we do know that every state has Native American people. People move around. And that law applies regardless of whether or not those individuals are from that state or another state. So I think that's a step in the right direction, but not enough yet.
So the dependency system as a whole really is, the purpose is to keep families together, to not break up families. And you wouldn't always know it to see the way that the system works. And they should exhaust every single option before breaking up a family, before removing a child. And with the Indian children, there are more options. There's a tribe, there's a government, there's a system, and there's a bigger safety net. And that you educate them on that every single case, every single time, every single paper that's filed. It doesn't mean it sinks in, but that whole process is really it's just a change of perspective that really you're trying to keep Indian community and children and families together. And it came from a place that most tribes and members don't forget, which is when their children were just taken away, put in boarding schools so that they could learn to be white. And so they've pushed back against that. Kids died. There's graves in Pennsylvania, wherever it is, where they don't even have names of the homesick children. That was part of what caused the effort or pushed the effort to keep this act vigorous. So yes, we will keep trying to do that. No, we can't do it overnight, but I think it happens pretty much in every case.
All right, last call for questions from the audience. Oh, yeah, I was about to say we're like right at time. Let's see.
Asking what network they're with.
Okay, yeah. Okay, I think you guys will be able to answer this one pretty quickly. Okay, so how are tribes encouraging education or mentorship in their own tribal democracies?
Yeah, I mean, every tribe's going to be different. You know,
Yeah.
I'm a small tribe, a member of, and you know, we have our own scholarship, committee, and they did not have that when I was going to school. So yeah, just scholarships and more opportunity and stressing it too, right?
Yeah.
Those different government departments I mentioned at Pechanga, each year, all of them take interns from among the tribal youth. So we have a youth department, they have a homework club, we have a scholarship department. But for practical skills, when tribal members reach maybe the age of 16 or 17, they're eligible to participate in internships with these various government departments, which gives them an idea about how the tribe works. It might be kind of satisfying their curiosity about a particular field they're thinking of going into. But it also, I think, gives them, I hope, a good feeling about giving back to their tribe and maybe instilling in them a desire to work for the tribe later as adults.
Well, and I would agree. I mean, I was benefited from my tribe and tribal scholarships for me to be able to go to college, university, and to law school. So certainly I have had a direct benefit from my tribe to be where I am today. But I also think that as a Native person and a Native woman, I were taught, and I was taught that I have a responsibility to give back and to turn around and to lift others up. So when I got to, became a lawyer and I became a state court judge and I became a federal court judge, I've always known and accepted that responsibility to make sure that I put myself out in the community to talk to Native youth, to put myself, bring Native youth to the courthouse, to have Native externs and interns and law clerks. So I think not only is it a responsibility of the tribal community as a whole, but it's also a responsibility of us as tribal citizens to ensure that if we're able to get to a space and we're now seated at tables that historically didn't have seats for us, that we turn around and make sure that we save room and help others get to those same tables and have youth understand that they have a place at those tables too. And so I think that's also important.
Many tribes have committees that aren't elected, so there'll be an education committee, there'll be an enrollment committee, a housing committee, children's trust committee, and from the earliest times, the youth, I'll say youth when they're 18, they're allowed to participate. They're encouraged to participate. So they have a role and a function within the government, even if it's not at the highest level. That's a way to to learn how the tribal government works, and that is real life education.
Great. All right. Well, I'd like to invite you guys to give a round of applause for our panelists. Thank you so much for teaching us something. I really appreciate it, and thank you all for being here.
Thank you.
Feel free to mingle for a little bit. We've got snacks and refreshments. But yeah, thank you so much. Oh, also, this will be available on YouTube in a few days. We